were engaged in an action that involved putting something to their lips, taking a draw, and then exhaling. I don't know what it is. But anyway.
Can I just make a quick announcement actually? Well, I suppose I should do it again at the end when people are here. But just so everyone knows, the barbecue tonight, very important, not really to our discussion, but the barbecue is in the Radisson Hotel, which is near the coach station. It's on the same street as the coach station if you came from there. So, and if anyone needs directions, talk to somebody in a purple t-shirt. But just so everyone knows, that's where it's on. It's the Radisson Hotel.
All right. Right, so now we're going to start this afternoon's session for the roundtable from 2 to 3:30. Eleanor tells me you have already been introduced to all of the speakers who are joining us here this afternoon. And obviously the idea is to get a bit of discussion and to continue the discussion from this morning and earlier, and to keep the energy going in the room. So the kind of questions we're pulling together is, the kind of thoughts that are coming to our mind, and I'll ask each of the speakers to maybe give a minute or two on each, is, first of all, how do people identify that they have a legal issue in your country, and each speaker will speak through their country, and search for solutions. Lawyers, clinics, NGOs, etc. And perhaps I'll just go through the panel with that question first. And maybe I'll start with you, Michael. Is that fair?
All right, fair
All
enough. I am the only gentleman.
Yes, blessed among women. Go on.
Thank you very much. I think in terms of the way people identify with access to justice within my local context, there are two issues here. First of all, there is access to the formal justice system, and there is access to the informal justice system, so to speak. And what I want to say like that is that a couple of weeks ago, the Chief Justice in Kenya said something very interesting. He said that 95% of people in Kenya do not access the court. It's only 5%. So the big question is, in terms of access to justice, where does the 5% go to? So, working around issues of access to justice, the approach have to be two. You have to look at the formal justice system, that is the court, and you also have to look at alternative means of dispute resolution, and also traditional means of dispute resolution within our community. Thank you.
All right. Lucy.
Okay, I'm going to talk about England. And my research focuses in particular on issues that arise in care services, so both home care and home supports, and also care homes, residential care and hospitals. And I think one of the issues that certainly come across, for example, in studies by the Equality and Human Rights Commission and other people, is that often issues that can arise in the context of care are seen as being interpersonal, quality issues rather than necessarily legal issues. Mm-hmm. And rights awareness is often quite low, and people are often diverted towards complaints mechanisms rather than perhaps legal channels, which might be more appropriate for certain types of disputes. The Equality and Human Rights Commission has also found that rights awareness is particularly low among people with disabilities. So I think there's some work that needs to be done around public legal education, that people are more aware of rights and of remedies to vindicate those rights. There are certain pockets of interest though. So England falls within the Council of Europe, so it falls under the European Convention on Human Rights. And Article 5 is quite an interesting mechanism, the right to liberty, because it contains within it very explicit duties to inform people of their rights and how to use appeal mechanisms. And that creates, it's kind of an interesting architecture because it creates a situation where people know how to challenge authority. And we're seeing more and more cases under Article 8, which is about rights to private life, where the courts are saying to local authorities, to NHS bodies, if there's a big dispute blowing up, it's not acceptable to wait for the person themselves to take you to court because of the imbalance of power, the imbalance of rights awareness. You should be taking these types of disputes that engage people's really fundamental rights to court. So I think there's a number of strategies we can look at. There's generic rights awareness, which I think is really important, but also there are certain types of issues where people who are in public service need to have stronger duties to actually inform people that when a disagreement blows up, how people can challenge that.
All right, thank you. Thank you, Lucy. Eilionóir?
Okay, well, Teresa, you're the more practicing lawyer here, so I'm not sure I should be talking about this, but in the Irish context, I think some of the things that Kelly mentioned this morning about people it would never occur to people to go to a lawyer, I think that's quite a universal experience. So I think that we would have that also. And I think we don't have, a huge number of disability law clinics. I mean, we do run one here in NUI Galway for members of the public who have questions about disability law, but we don't have things like student practice orders, so our students can only provide legal information and they can't actually work with people and represent them. So that's one of the issues I think that comes up, and I think that there are NGOs and some DPOs who people will go to first, maybe with a legal issue, and it's only if those NGOs have good contacts with lawyers that they trust, that have worked on these cases, that have knowledge of representing people with disabilities, people like Teresa, that there's going to be any chance of people actually being able to pursue their case. So I think that's usually a huge barrier for people in the Irish context.
In the U.S. context, I think this is echoing what Lucy was saying. There's a real lack of accessible information about how the justice system works and the rights and responsibilities of persons with disabilities within the justice system. And there's some research done, it was a while ago, on the knowledge of persons with disabilities, awareness of persons with disabilities in the U.S. about the Americans with Disabilities Act. And it was sort of shocking in that its results were disclosed that fewer than 50% of those persons surveyed knew what the ADA was. So I hope it's a bit better now. If we were to do that survey, it would be a bit better than it was then. But we do have a lot of awareness raising to do. At the Burton Blatt Institute, where I work at Syracuse University, one of the things we're doing is we have a big project that's trying to promote access to lawyers and legal services and representation in the context of disability benefits through Social Security, because the percentage of people who have access to lawyers in that process, it's supposed to be very accessible. It's not. It's a very complex process. And most people are denied, the vast majority of people are denied initially when they apply for disability benefits. And so what the Burton Blatt Institute is doing now is providing legal representation for persons with disabilities in the appeals process when they're appealing the rejection of a disability benefits claim. And we know that when persons are represented and have legal counsel, the rates of success go massively, massively up. And that's in its early stage now. It's been going for about a year, but they're filing over 200 briefs every month in that process. My colleague Kelly Bunch is running it, and it's really important, I think, important area of advocacy that's been has not really been addressed much in disability law clinics in the U.S.
My experience with access to justice in the United States is actually more with domestic violence and sexual abuse, so different area than what Janet just spoke about. And I think in this area in particular, but probably across different areas of access to justice, the issues of voice and choice, as we've been talking about, are key. The first one is like when someone has survived domestic violence or sexual abuse, just getting heard in the first place by anyone, and then by the police is then another barrier. And then once you make it past the police, if the police actually listen to you, then the prosecutors actually taking you seriously is a whole other barrier. So, and it's both having your voice heard, having the space to to express what's happened to you, and then having your choices listened to based on what you want to happen after that. And I know personally and through work that I did, those are huge problems in the United States, and I imagine actually that's a problem that exists in many other jurisdictions as well. And it's one area that I think really needs to be looked at is evidence law and how testimony is taken and the different interactions between the parties in the system are really in many ways working against people with disabilities and people with cognitive disabilities in particular, psychosocial disabilities and intellectual disabilities. Many people I know with intellectual disabilities especially are just told flat out that their testimony won't be taken seriously in a courtroom and won't be eligible for being in the courtroom. So their whatever they have survived isn't even prosecuted on that basis. So that's one of the key problems that I've encountered in the United States anyways.
I'd like to echo Lucy's
point, because it's a big issue in Australia too about the residential context of access to justice, because what does happen is, as Lucy was saying, that if there's domestic violence or sexual abuse within a residential care situation, that it's treated administratively and not even defined as a criminal or justice issue. And many times it's the victim who then gets removed from their residence rather than the perpetrator. We have a fairly good community legal structure within Australia, poorly resourced of course, but it has historical flaws in terms of funding, both in terms of the amount that's funded, but in terms of providing integrated specialist legal support, free legal advice for people with disability. There are only two holistic specialist legal centres in New South Wales, in the state that I'm from, and they are defined on disability type for intellectual disability and psychosocial disability. There is no generalist integrated specialist disability, free disability legal advice services in Australia. So it's very problematic. Though the Productivity Commission is at this moment reviewing access to justice services in Australia, and we're hoping that there will be a better integrated process to come out of it, both dealing with the dodgy historical funding structure around community legal services, in particular disability specialist services, but also streamlining the primary referral process from disability advocacy organisations to give a path from DPO advocacy organisations through to secondary casework, community legal, free community legal services.
Thank you. Thank you. I might just add an observation, and thanks to Anna Lawson for this earlier this morning. We're talking about access to justice around the world. We just commented to one another how often in certain areas of law there's a separation between academics and researchers in the area and practitioners in the field. And I have to say, in my experience in the area of disability law, this emerging area, there's a greater deal of participation and mutual cooperation. And equally, what comes across in the approach is the multidisciplinary area. I mean, I'm absolutely certain the majority of people in this room are not probably lawyers. And so the importance that other disciplines brings to informing a legal analysis or a structure or participation is absolutely vital. And Eilionóir made the comment, as a practicing lawyer, obviously a vital person that I encounter when I'm taking instructions from a client is, of course, their advocate, or the person who is interpreting a complex report in easy accessible language for them, etc. And that's vital. So there's very much an interrelationship between practice and multidisciplinary, and I think perhaps other areas of law can learn things from the way we're proceeding in this area. But I take on that question that I gave to the panel in this roundtable session, is there any one observation from the floor just to keep us in communication with one another? If not, I'll move on. Yes, one observation. I saw this gentleman up in the middle with his finger up first. It's almost like an auction, isn't it? He's going to buy the Renoir here behind me. Right. This gentleman here, I think he's earlier told me you're from Belgium, isn't that right? And then we'll prepare for our next question for our roundtable participants after this.
Okay. I have one remark to make,
Yes.
and I have two suggestions based on that. I led a study into monitoring the CRPD in Belgium in the past year, and what we noticed is something that has been said many times in this course as well, that there is a very low awareness among persons with disabilities and other stakeholders with regard to their rights. Now, if we ask participants in the study how to change this, you get these, what I would call stereotypical answers, like we should have awareness-raising campaigns and things like that. Personally, I don't believe in this. And I think, given the European context, we should also provide more attention to two main actors, or two solutions for this problem of low awareness and therefore low participation in legal procedures. First is civil society. I think it has, in countries like Belgium, with a long history of a welfare state, civil society is hugely important, and it's a completely different context than many Anglo-Saxon countries. And second, I think we should also be aware of the importance of policy measures to prevent legal action. So I think that by designing policy measures that are in line with the convention, states can avoid that people have to take individual action to claim their rights. So in the field of work and employment, for example, I think a number of measures have already been taken in European countries, and more measures can be taken that kind of avoid that people have to individually engage with law and with potential discrimination.
Right. Thank you very much for that observation. Certainly there's food for thought in that. Thank you very much. Now, the second question that I'm going to put to the panel, just to try and pull the threads together from this morning and individually, what are the experiences of lawyers, practicing lawyers, judges and jurors with disabilities in your countries? Are there legal barriers to becoming a lawyer, judge or jury if you have a certain disability? And maybe since the microphone is down at your end, Chris, we'll start from this end up.
Australia doesn't have a really good record of having people with disability in juries. Actually, it's a really, really, excuse the language, really crap record of having people with disability in jury. I'm one of the management committee members of a specialist disability legal centre that has a human rights law practice as well as a discrimination law practice. And we're currently running several cases in a couple of states in Australia on jury access for people who are deaf. And the judgments we've just recently had have been very heartbreaking in terms of these nonsensical arguments about having a 13th person in the jury room. It's just gobsmacking. Luckily we're still in the lower courts, so hopefully on legal review we can get a better judgment. But if these judgments stand, and in Australia unfortunately disability discrimination hasn't had a good run in the senior courts over the last 10 years, if an adverse judgment stands in the higher courts, I don't see us getting people into juries for a good while, though we are looking at individual communications through to the UN, but everybody's aware of the time frame of that. In terms of studying for law, well, I'm a lawyer. Not that that necessarily says anything other than the fact that I'm a lawyer. Like all areas of academia, it's the historical disadvantage that is the greatest barrier to people with disabilities getting through into the law. Until we've addressed inclusive education, I think we will always see lower numbers of students with disability participating in law programs. Though I've taught law for 10 years, and I've seen an increase in the cohort of students with disability that I teach in the undergraduate program and the JT programs. So it's increasing. The judiciary, well, I know our friend from Brussels says it's trite, but God, could they do with some awareness raising? Seriously, could do with some awareness raising.
Since I'm not actually practicing in the United States, I'm going to let Janet answer most of the question. But I will mention that I think one big barrier that's kind of an indirect barrier is that the Individuals with Disabilities Education Act does not provide any significant right to secondary education. And I think that's a big barrier for entering these kind of professions that require high levels of education. So I think, take it away, Janet.
I'm not really practicing in the US either, but I can refer to some research that we've done on access to courts for persons with disabilities, obviously a narrow area, but an important one. We've looked at access to court facilities, access to court procedures and policies and court programs and services. And there's been some interesting cases that have come down the line on one, serving as a witness. So we had a case in Georgia where a witness who was blind testified before the jury in a criminal trial for rape. The court held that the jury could properly rely on the testimony of a witness who was blind. This reminds me to link back to the political participation session this morning of some incredibly hostile confrontation that I had with the head of a civil society organization in an unnamed country, who insisted to me that it was absolutely absurd for a blind person to serve as a observer in an election observer mission. I mean, he just couldn't wrap his head around that at all. He further said he would allow persons with physical disabilities to be observers, but only in the morning, because the count could go quite late into the night, and he didn't want those for people to be staying up all night. So, anyway, other couple cases just to highlight, serving as a juror. We had one case, again, there's been a lot of Georgia cases. A criminal defendant argued that a juror who was deaf in his criminal trial should be disqualified from being a juror, and the court held that the trial court properly denied the criminal defendant's motion to disqualify the juror who was deaf, and that a juror's inability to hear is not a disqualification. Another case, the court held that the categorical exclusion of a person who was blind from jury service was a violation of federal disability law. And we've had some other interesting cases about serving as court observers and accessibility of court services. And in the U.S., even though we've had the ADA for a very long time, we still have implementing regulations regarding accessibility of courthouses and court services are still in the draft stage, so they haven't even been adopted. So this is actually still a really rather new area, surprisingly. In the context of international cooperation and development programs, where the European Union, the U.S. government putting millions and millions of dollars into court reform across the world, very often they're not thinking at all about issues around access. So there's a lot of work to be done.
Can I just clarify? I accidentally said secondary education. I meant post-secondary. The IDA doesn't provide a significant right to post-secondary education. Yes.
Thanks. Yeah, this is one of the things that I'm really interested in, so I'm glad we have this question. And I think I'll start with the juror stuff, because similar to what Rosemary described in Australia, we've had actually strategic litigation from a deaf juror who was excluded from a jury here, unfortunately. It's quite a confusing judgment that was produced. So
That must be required.
yeah, so it says that she shouldn't have been excluded at the point of entry, but that having an interpreter in the jury room could violate the 13th person in the jury room common law principles. So it's a little bit tricky. And I know that Michael Farrell, who works for the Free Legal Advice Centres, who comes in guest lectures in my class on access to justice, has been involved in finding other deaf jurors to go and challenge this with. So I know that it's ongoing. But actually, not just for deaf jurors. There's still a provision that it was reformed in 2008, which says that now it says persons who have either an incapacity to read or an enduring impairment such that it is not practicable for them to perform the duties of a juror should be excluded, which is not amazing, but not as bad as it used to be. But interestingly, it hasn't reformed a piece from the 1976 Act, which says the person who suffers or has suffered from mental illness or mental disability, and because of that is either resident in hospital or another similar institution, or who regularly attends for treatment by a medical practitioner, is not eligible for jury service. So if that was interpreted strictly, there's a lot of us who wouldn't be eligible for jury service. So I don't have any concrete examples of someone being excluded really on that basis. It may have happened, it may just be that I don't know about it. So that's quite interesting. I also want to kind of draw the attention to the idea about lawyers and judges. Again, I suppose there aren't that many formal barriers as such, but just that the sort of practical disadvantages of going through professional legal education and into practice can be a bit tricky. But even more so than that, I think what's interesting is maybe some of the more invisible disabilities where people can pass as non-disabled, and especially thinking of psychosocial disability sometimes. So I wonder, Michael Perlin writes a lot about how many judges actually have psychosocial disabilities, if only they would admit it. So that's quite an interesting thing to think about. You know, we think, oh, we don't have much visibility or representation of people in positions of power in the justice system with a disability, but maybe if more people identified, we might have. So that's just something interesting to think about.
All right, thank you, Eleanor. Now, Lucy.
Okay, I should say first of all that my research on access to justice tends to focus more on clients rather than lawyers and judges, which I will be remedying straight after this summer school. I would say, I mean, the situation in England is not dissimilar to the situation that Eleanor's just described for Ireland. There is a general problem on the judiciary in the United Kingdom around the representation of people from all kinds of marginalised groups. There are a tiny, tiny number of women, particularly in the senior judiciary. Representation of people from black and minority ethnic groups is also very low, and there's been a huge amount of attention paid to that, but I haven't noticed a great deal of attention about the identical problem around representation of people with disabilities amongst the judiciary. We've had quite a lot of changes to our tertiary education system, so our university education system in the UK, and that I think will probably disproportionately affect law students with disabilities, or would-be law students with disabilities. So there are currently cutbacks in supports for people with disabilities in education. We in the UK have just introduced very, very high tuition fees for attending university, and in the UK people with disabilities are disproportionately likely to come from low-income backgrounds, so that will disproportionately affect them. But there are some glimpses of good news in amongst all this. The kind of barriers Eleanor was just talking about for people with mental health problems sitting on juries has, I'm pleased to say, just been removed in England. We had the Mental Health Discrimination Bill 2013, which removed that barrier, so that was great. And actually, a knock-on consequence of debating the Mental Health Discrimination Bill was that a large number of elected members of Parliament stood up in Parliament and spoke about their own personal experiences of mental health problems to try and combat stigma. So that's helped to open up a kind of more inclusive conversation there. The Law Society, who is the body representing solicitors, is doing some work on supporting lawyers with disabilities, and I'm pleased to say that some law schools, I can't speak for all of them, are doing really good work supporting students with disabilities. So I'm at Cardiff Law School, and we have a disability officer who looks to make sure that the relevant accommodations are made to support people. We have some fantastic students. One of our students, Reese, has autism, and he just addressed the Welsh Assembly about being a law student with autism, and how actually it's a strength in terms of helping him to organise information and learn large quantities of law. So it's not brilliant actually, but there are glimpses of light in there.
Okay, I have to admit I might also not have a lot of experience in terms of representation in the judiciary and all that. But I think one of the things I want to say is about opportunities to education, that of course persons with disabilities, due to a lot of barriers in our communities, be it poverty, be it stereotypes, they're not able to access education on an equal basis with others. So that for me could be a very big barrier in terms of people wanting to be lawyers within our society. The other thing, and this is maybe probably specific to persons with psychosocial disabilities, is that they tend to take longer sometimes to complete their education within the education system. So one of the challenging is then what would reasonable accommodation look like in that particular context, which means I might not take the 5 years to complete my university education, and some of the students are actually discontinued in relation to that particular basis. I think that would be my perspective in relation to education.
Thank you, Michael. And now I'll take one observation from around the world. You're. Well, if there are a lot of hands up, maybe two.
Yeah, I just want to make a couple of points. One of them is that I think it's certainly in Australia, and I think and certainly from our study last year in England, one of the issues was that certain lawyers get named around the communities as specialists in working with people with disabilities, and I think I can understand that is very reassuring for people. But at the same time, I think it leads other lawyers to just absolve themselves of any responsibility for working with groups of people with disabilities. And I think that's a problem that we need to address. I'm not quite sure how, but I'd be interested in whatever the panel has got to say about that. And the other point I'd want to make is that somehow educating the judiciary, I mean, having more people with disabilities as judges is a good start, I guess, but somehow finding ways for professional education to be used much more strongly with judiciary. I remember repeatedly judges and magistrates confusing intellectual disability and mental health issues, and completely they just couldn't see that there was any difference. So I think there's a lot of work to be done there.
Thank you very much. I saw the lady in front of you. You wanted to make a comment on this matter, didn't you? Well, would you like to?
Thank you. I talked to Eilionóir about it a bit earlier. It was just in Norway we have a case now that is there's lay judges that have been laid off their work really because of their disability. There's one blind one and a deaf one. And it's all now going to the Supreme Court, and what they're using as an argument for laying them off is that because you have to have a good enough understanding of Norwegian to be able to be a lay judge, and they're using that as a comment on how they cannot understand what's the court proceedings properly if they're not, if they can't see or can't hear. So that's going up to the Supreme Court now and see what they do with reference to the convention that we ratified last year, but then we haven't ratified the protocol, so we don't have anywhere to go after that, but we'll see what happens.
That's very interesting. Yes, thank you. Now, there was this gentleman, I know you were anxious to make a contribution. We'll manage the timeline now. Thank you.
Thank you. It's just interesting. I just want to say, the problem is not with litigation or the litigation process. It's the whole judiciary system. How people with disabilities can access the judiciary system or can access to justice. It's not only about court and judges, it's also about complaining in the police center, it's also about being in prison, as criminals also.
Yes.
It's also about being in as witnesses in the court, as judges or lawyers or anything. The whole issue is related to three categories of obstacles. The physical obstacles, the barriers, including whatever about accommodations and accessibility. We know it all from the book and the paper or the whatever screen in the court room, or even the stairs to go upstairs to the court or to the police center to make a complaint. Also, it's about attitudes. And this is a very large cultural issue. Attitudes usually make people you work with unable to accept you. They create walls, not only barriers, walls. They don't, in my country, they don't see a blind person as a judge. They don't agree as a blind person to be a judge. They don't see a blind person as a normal thing to be a lawyer. I studied psychology, I studied social work, I studied management, also I studied law, but if the whole thing is possible. But when I came to finish law, everyone, wow, blind and have a law degree. That means what my friend a little while ago mentioned, that they cannot access. We can access education. Education is a big agony. I had to translate, to retype every page of like 35 courses I had to take into Word format again. Nothing was available. For 3 years I had to suffer and to pay a lot of money only for copying books. The third issue, the fourth issue, besides culture, attitude things, the physical accessibility, yes. Also the institutional thing, the laws, procedures, the regulations. They don't allow people with disabilities usually to access the system, because the laws is a big source of rights. It's a source of rights. And if they are not really well designed and well done, they will really exclude instead of include people. The fourth and the last point, which is people with disabilities themselves. They usually keep silent many times. And this has to do with a lot of factors: the priority of the country, the priority of the people, the priority of the families, which is best, which is now is a knocking issue, and what issues can be delayed. And disability varies in its level of existence on the ladder of, or in the scale of priorities, from a year to another, and sometimes from 1 hour to another. Thank you.
Yes, thank you very much. A lot more hands coming up on that. I'd certainly make the observation that certainly when I was studying law, there was not information accessible for students with a disability who maybe needed textbooks in Braille or whatever, and they were often dependent on a colleague to read the content of a law book to them and put it on a tape or whatever. So huge advances need to be made in that area, and certainly those observations are all apt. I see just 2 hands up at the back. I see Anna Lawson, and behind Anna there's another lady.
Thank you very much. Really interesting question, which I'm really interested in too. Yeah. I think one of the points that may be worth making here is that there are often really powerful organisations, or if there aren't, then there could be at national level. Like in the UK, we have a Society for Disabled Lawyers and also the Society of Visually Impaired Lawyers. And I know they've campaigned very vigorously for participation of disabled people in the justice system as lawyers and judges. And I think it was partly due to their influence that we now have a blind judge in the UK who's received quite a lot of attention, because it was quite controversial a few years ago whether he should be appointed as a judge. So he's the first UK blind judge. Yeah, there are other points, but I'll leave those. Thank you.
Thank you, Anna. And there was a young lady behind you who wished to make a contribution.
Yes, I just wanted to, it's Berit Vegan from Norway. I just wanted to fill in with Camilla there, because the Supreme Court of Norway has ruled that a blind person cannot be a lay judge. So that has actually happened, and they did no reference to the CRPD at all. So it will be very exciting now to see if they will go to the European Court of Human Rights, because there's no other option in Norway now.
Oh, thank you very much. And there's the last one, the gentleman in front, just the gentleman with glasses. This is the last one.
See, I have a very different opinion to make about the access to justice, about lawyers with disabilities and judges with disabilities. I am from India, and I feel that problems are everywhere, but you should take everything as cutthroat competition. And for lawyers with disabilities, although problems are there, but if you can prove yourself, there is no problem. I am a practicing lawyer there. I have done a number of cases. I have even got driving license for deaf people, insurance for disabled people, and a number of cases we have done. Even more than 100 lecturers have been appointed. So we have been doing cases, and so far as judiciary is concerned, although there are very few judges with disabilities, as such, I do not remember who are in High Court or Supreme Court, but I must say that judiciary has done a commendable job in realization of rights of persons with disabilities in India. In terms of for psychosocial disabilities and intellectual disabilities, there may be a very few judgments, but yes, for physical disabilities, from access to franchise, access to right to vote and other things, you can find a number of judgments. So judiciary is very progressive in India, and whatever rights of persons with disabilities have been ensured in India, that is through court and none other, not than by any other system. So lawyers with disabilities are also performing very well. Apart from me, there is Mr. S. Kerunta, he is senior advocate, and both of us have been doing a lot, and persons with disabilities are very vocal there. They are able to make their presence felt everywhere, despite the fact that we are not in the political system, we are not in Bollywood, Hollywood, anywhere. Yet, yet persons with disabilities are not ignored. Even once the government was trying to introduce an ordinance to bring about a new act, which the persons with disabilities were not feeling apt for, they were feeling that old act is better than the new one. So government was trying to force its ordinance. Persons with disabilities demonstrated. Police came very heavily on them. Yet, the government was forced to not to bring that ordinance. Thank you so much.
Thank you very much. I'm going to move on now to the next issue to put to members of the round table here. Michael actually referred to it in his answer to the first question. We're talking about access to justice and the global perspective. What about alternative dispute resolution mechanisms and informal justice systems in your own countries, be they community, tribal, religious, or whatever? And perhaps we'll start with you, Michael. Thank you.
Okay, thank you. And that's why initially I think I said for us, the approach have to be two-pronged. You really have to look at the kind of informal systems of dispute resolution which are within our communities, even as we try to complement that, of course, with the formal justice system. And basically people live in the communities, and a lot of disputes when they arise in those particular communities, probably you're going to go to the village chief, probably you're going to go to the village elders, or any other local administrative, organ to be able to address that particular issue. And then remember that this is a low resource setting. So if you're talking about fundamentally maybe people going to court, where the system is adversarial, the court process is complicated, then of course informal systems of dispute resolutions become very, very important. And in our country, this is something which is actually recognized within our constitution. And like even in the legal aid bill that we are currently discussing, that is actually one of the avenues which have been recognized in terms of access to justice. Now, the only problem is that sometimes, of course, informal systems of accessing justice have their own challenges. I remember one case we were dealing with, an issue of land. And this lady, the family wanted to disinherit her from that particular piece of land. So of course, and she has a psychosocial disability. So when she goes to the chief, of course, the chief thinks she doesn't have capacity. Then she had to go to a sitting of elders who basically consist of, all are men. So at the end of the day, there was a lot of prejudice. And now we had to resolve actually to looking for people who would actually support us to take that particular issue to court. So there are also barriers in terms of traditional means of dispute resolution. And I think when we were having discussions, we said that sometimes in Nairobi, a couple, I think it was last week, we said sometimes that culture can be changed in time. Whether we want to use public education, for example, to speak to the elders, to understand how to sort of deal with things informally in the context of the Constitution or other human rights framework, that is very, very important, that kind of public education and engaging with those informal systems. Or whether you want to use, for example, statute laws to be able to remedy some of the injustices that are actually occurring within our informal justice system. For example, we've had a big issue of female genital mutilation in Africa, which was a cultural practice. And again, sometimes you have to enact statutory law, especially when those kind of cultures are repugnant to natural justice or basically against the Constitution. So what I want to say is that they are very, very important, they are very, very effective, but then we also have to look at, are they within the general human rights framework within our community, and are they repugnant, of course, to natural justice and the rule of law in that particular community? Thank you.
Thank you. Lucy.
Thank you. So there's growing interest in England at the moment in alternative dispute resolution. I'm sure this is true in a lot of countries because of cutbacks to legal aid. So as formal justice becomes more inaccessible for financial reasons, there's more and more interest in kind of extrajudicial mechanisms of resolving disputes. So the government is very keen on encouraging people to use mediation. The trouble is, cash is a barrier to mediation as well. Mediation costs money, so that's not always a great solution. There is growing use of mediation around disputes relating to legal capacity issues, care and welfare and health issues. I think on the whole, if you can avoid going to court, that's a good thing, but we need to be very, very cautious here to make sure balance of power issues are addressed. And I think that applies to all kinds of users of mediation services. I mean, it applies across the board, but it does apply also to people with disabilities. And I think there's a real need for guidance, particularly where legal capacity is concerned, actually, about what a resolved dispute looks like. So is a dispute resolved if everybody else is in agreement except the person with a disability about what should be done to them? That's a real danger in a legal capacity, mental capacity framework. And also sometimes trying to divert people away from extra legal mechanisms can actually just create more barriers to accessing justice where you really, really need to. We also have an ombudsman in the UK, in England, Wales, where you can take complaints. There are all kinds of different ombudsmen for all kinds of different complaints. They tend to be slightly more accessible than formal legal procedures because you don't necessarily have to fill out so much paperwork. There are less rules and regulations on who can help you make a complaint and access those services. It's much more informal. There are still barriers there, though. There are plenty of studies showing all kinds of barriers around awareness and confidence and use of the ombudsman. One interesting growing area, particularly around legal capacity and care disputes, is the use of advocates. So there are a number of studies which are suggesting that where people have access to independent advocacy, and the role of the advocate is to help them express their wishes and participate in the process, that in itself can resolve certain types of disputes because people feel heard and listened to, and it can make it clearer what a person wants. So advocacy is also an interesting mechanism that can sometimes divert people away from the need to go to court.
Thank you, Lucy. Now, Eleanor.
Thanks. Yeah, I think alternative dispute resolution is a really interesting way of looking at the participation and inclusion of people with disabilities. I know that in the deaf jurors strategic litigation case, for example, they tried to argue that because sign language interpreters had been used for mediation, particularly in family law cases, that this, showed that they could perform this role without interfering with the fairness of the process and so on, and could be impartial and independent and maintain confidentiality, although ultimately that argument didn't quite succeed for them in that particular case. But I think it's interesting. I don't know as much as I'd like to know about informal justice systems, but they fascinate me. And I was lucky enough to have a master's student last year who did her thesis on sexual violence against women and girls with disabilities in Zimbabwe, and looked at the informal justice system there and how disputes get resolved, which was really interesting. Some of the issues that she came upon when she started to interview people were, the ideas about what actually gets done, what is the justice in that situation. So often if someone reports that they've experienced sexual violence or they've been raped, the resolution will be for the two families to work together to come to an agreement. And sometimes the agreement is that the two people should marry. Sometimes it's sometimes it's compensation, financial or otherwise. So, I agree with Michael, it can be a really excellent form for achieving effective access to justice, but we really need to look closely at what are the principles guiding that, and can we do more to kind of, again, peer education in that, I think, as well, would be really, really helpful. Just as helpful as educating the judiciary, I think, and I think the best way to do that as well also is to hear from peer judges, who understand how to communicate with people and how to be flexible and accommodate different requirements. And I would just say as well that while I think the informal justice system in many countries will be the first port of call for anyone, and they really will not want to use the formal justice system, not find it helpful to them, that there should be a clear delineation when you can exit from the informal justice system, when you feel that it's not achieved the outcome that you want, and effective access to the formal justice system from that. Those would be my comments.
Gone down to the end of the line there.
ADR is, as Lucy indicated, a growing area in the justice system. A major piece of national legislation has written into the legislation that people have to go to arbitration on any complaint process under the legislation. So they're directing all complaints under the National Disability Insurance Scheme through the ADR process. A bit like Eilionóir, we don't have an informal justice system structure, though we do in Indigenous, in our First Peoples community, we have court circles. And there's a large representation of disability within our Indigenous community. The prevalence is about 37% in the Indigenous community of disability. And there's been no formal evaluation, but anecdotal evidence suggests that some of the circle courts can be very good for diversion practices for Indigenous Australians with disability in the justice system. I mean, people with disability are highly overrepresented within the justice system, and unfortunately within our Indigenous community it's even higher overrepresentation. So, and the diversionary practices that are in place are generally very inadequate. It would be good to get a better sense of how the circle courts go, and if they are making a significant difference. But as I said, at the moment it's really only anecdotal and we don't have a lot of concrete evidence about it. But it would be interesting to see, because in the area of intellectual disability, people would get caught in the justice system for the simplest things, generally for revoking bail, for things that have come up like unpaid transit fares. And because the bail conditions don't get explained or the fine system doesn't get explained, you then end up with a person in the criminal justice system for the simple thing of not knowing about paying a fine for not having a train ticket. And once they're in the criminal justice system, it's very hard to get them back out.
Thank you. Thank you very much, Rosemary. That's very, very true. And, you know, that person, I remember representing a person with a learning disability, was constantly just not able to turn up in court on time, and there was constant bench warrants issued for his arrest. And it was really just this whole thing about, you know, attending to time and understanding 10:30 and a Thursday morning is 10:30, and if not, and suddenly somebody finds themselves with 20 or 30 bench warrants, which is disastrous. But Rosemary, yes.
One positive thing that we do have in New South Wales, in particular, the state that I'm from, is a court support program that's run by the Intellectual Disability Rights Service. And the court support program is about providing a court support person for a person with an intellectual disability that is has got themselves into the justice system, and that person helps them deal with all that. There's a huge program around it in terms of preparing people for their particular court appearance and then the process that happens afterwards. I mean, it could do with a lot more funding, and it could do with being spread much more widely, both within New South Wales and throughout Australia. But it's an excellent program, the court support program.
Brilliant. Oh, thank you. Just in terms of, we're moving on to the next issue we're going to talk about, which is in the criminal system, yes, but maybe reminding us that we were discussing the alternative dispute resolution mechanisms, the emphasis on mediation, informal, etc. And in Ireland, we have, of course, an emphasis now on trying to develop the mediation services and going to court as the last resort. So perhaps one or two observations now from anyone who would like to give us an observation on Miriam. Is it yourself? Right, your observation. Sorry, the microphone is in just the middle row.
I just want to add on what Michael says about alternative dispute resolution and say that Kenya National Commission on Human Rights runs a program that is culture and human rights and basically focuses on the various groups within the community. And what we do is to make sure that these traditional mechanisms are able to be trained on issues of human rights, and when they're making their decisions, they know that they should not go beyond this because they're going to violate human rights. And we have done with two traditional mechanisms or groups, what we call councils of elders within the community. And one of the success stories of this intervention is about the female genital mutilation. And in the next program that we are running for legal capacity is one of the issues that we have planned to do to make sure that now, as the advocacy that we did on issues of genital mutilation, then we move forward on issues of disability and include issues of legal capacity. And this is going to ensure that even when the Council of Elders are making decisions, because persons with disability, they are not being featured a lot in the discussion of health, then they are able also to know what exactly happens within the community on issues of persons with disabilities.
Thank you very much. It's very innovative kind of work there. That's excellent from the Commission. Kenya. Okay, we move on to the our next. Is there another question? Yes. Okay.
Yeah, I would like to just maybe refer to the Zambian scenario. The informal sector, which is more or less like maybe for Kenya, there's a lot of paralegals on the ground. The paralegals are being used because, for instance, Zambia, we have a population of about 13 million and lawyers of about 1,000. So it's almost impossible to get representation. Most of the people use paralegals for mediation and other things. But what I've realized is the paralegals themselves lack educational support. Like this issue of disability, if even in this conversation, we are talking it at a very higher level. So I wanted to know from Michael if there are deliberate policies in your country we can learn from to empower paralegals.
Okay.
Michael, thank you.
I think one of the things that we do within our peer support groups is also to identify people who can work specifically with our groups, as paralegals within those particular groups, people who have created relationship of trust, and people who really understand the issues of the persons at that particular level. The other thing is from policy perspective, in terms of what I'm talking about, the legal aid bill. And the legal aid bill, what we've done is we've established justice advisory centers within the community level. And these justice advisory centers are supposed to be manned and run by paralegals. And part of their mandate is to go into the community and sort of pick out issues that are happening in the community, bring them to the justice advisory centers. If it is something which can be mediated and dealt with at that particular level, it is okay. If it is something that actually needs to be taken to court, then support is provided at that particular level to be able to take that particular issue to court. So I think that's basically our approach from a practical perspective, and also the way we are trying to look at it when we are legislating on the legal aid bill.
Okay, thank you. I just any more contributions? Any further contributions on this? I think the common theme is legal aid bills resulting in a cut down in resources, at least in Europe, and then a drive towards alternative dispute mechanisms after that. Okay, the gentleman at the back, just a contribution.
I have one apprehension on this alternate mechanism system, because if the alternate mechanism is developed, let's suppose I am a victim of sexual violence, I am a victim of rape, and I may be compensated, or I may be married to a man who has committed rape on me. It actually puts at least women with disabilities in more problematic situation. That usually it will lead to that it will basically force all persons with disabilities to compromise somewhere, because otherwise persons with disabilities are in any way considered a very, I will use this term which was, we are basically told not to use, vulnerable. And people would say that, why are you going to court? Irrespective of the fact that I want to prosecute the person, because it is not my choice. I do not want to marry with that man. I do not want to receive compensation. I want to prosecute because it is a deliberate, it is a intentional error which the person has done. But if this alternate mechanism comes into being, I think being a person with disabilities, I do not know to what extent I'll be in a advantageous position.
I think what I suppose in discussing alternative dispute resolution mechanisms, I think it should be clear in any legislation or statutory framework that there are certain circumstances which would never come within that system, such as criminal offences, rape, etc. But maybe Eilionóir or anybody else wants to contribute to that.
No, I should have said that when I gave the example that my student communicated to me. What she was finding was that while legally speaking, these informal mechanisms weren't supposed to deal with these kinds of cases. They were supposed to refer them to the criminal system. They were just dealing with it anyway because the families were coming. But I think you're absolutely right, Teresa, about needing to clearly delineate and have a right of exit from the informal justice system where it hasn't achieved justice.
Right. And of course, alternative dispute resolution mechanisms, they're not compulsory anyway. While a court might say, have you tried resolving it elsewhere? If somebody says, well, I want to go to court anyway because I think I'll get a better hearing there or whatever. But certainly there's a lot in it, and I think, practicing lawyers would say that if you can use settlement, which is 90% of how cases are worked out anyway, it's better than going for adjudication, and give people ownership of solutions, etc. Now we've spoken about the whole education process, about access, etc. across the globe from all of our panel here. And now the next issue we're going to look at, and it was touched on this morning, and just to pull it together, what about where people with disabilities are perhaps offenders in a system? What about issues of fitness to plead, requirements in the course of a trial, post-trial, sentencing? Then if that person is convicted, detention, places of detention, reasonable accommodations, and unfortunately in practice I have often seen that it is only when a person who has had a disability has been convicted that in fact they have had access to a treatment regime that they didn't have previously. So I look forward to all members of the panel giving their contribution on that. Maybe we'll start down at the far end again with you, Rosemary. Is that all right? Thank you. We're talking about on where the person.
Yeah, it's fine for me to start. Once again, Australia's got two.
Is it turned on?
Sorry, keep talking.
Yep.
This is, he was just saying that this one
Is on? Yeah, so you don't have to.
Sorry.
It's okay. Australia's got two cases that are very prominent at the moment within Australia, but that doesn't mean that that is all the cases that are worth noting. There are several others across Australia, though these two cases involve both Western Australia and the Northern Territory. Marlon Noble and Roseanne Fulton. Thank you, Helen. These are both cases of indefinite detention resulting out of being unfit to plea. Marlon Noble was in jail for 10 years. He was never convicted. It has since turned out that he did not commit the crime that he was accused of. But Marlon is now under 24-hour watch with a disability support worker that he has to be in line of sight of for an indeterminate period of time. So whilst Marlon is now out of jail, Marlon is still being constrained in his lifestyle in some way. Roseanne Fulton is an incredibly sad tale, but yes, picks up the point, Teresa, that she didn't get help that she needed until she got into the system. She had been physically injured by people that were using her for sex, so she couldn't flee them, and she's been able to get treatment since she's been incarcerated for those injuries that were perpetrated on her. But again, it's come from simple fines and an escalating of petty crime that has ended her in this situation where she is now in an indeterminate period of detention, and it's unclear what the options can be for her. There is debate even within her legal team about what should happen. What has been the result of some of these cases of indefinite detention has been the creation of disability justice centres, which I'm really embarrassed to say Australia, 2 states have gone down the line of, and a 3rd is contemplating. And basically what they do, they have built jails with different titles to house people with disability who are not convicted of crimes. It raises the question about whether people would be better to have a well-resourced criminal trial process where they are supported through that process and to actually have their day in court, so to speak. Whether we could get to a situation where our justice system is enlightened enough and resourced enough, and people would be supported both legally and their disability supports as well, is unknown. But it really does raise the question that whilst we have the unfit to plea mechanism, that people will be lost in the system. And it's a sad indictment on our justice system.
Thank you, Rosemary.
Yeah, I think interestingly, a lot of the issues that come up in terms of people with disabilities that are defendants or are involved in the criminal justice system in that way as convicted criminals, a lot of the issues are related to legal capacity, actually. And they actually bring up bigger questions about about the way the whole criminal justice system works and whether it's an effective system in general. And one of the big issues, which I'm sure some people in the room are already familiar with, is the insanity defense. And the right to legal capacity in Article 12. So the right to legal capacity is both an equal right to legal rights, to be a person, but also to be an actor before the law, which means equal rights and responsibilities. And people have argued, including Tina Minkowitz, I think the most succinctly, that requires the abolition of the insanity defense. And I mean, I think that's a good argument, and there's also other good arguments for the abolition of the insanity defense. One of them being that it results in indefinite detention, similar to what Rosemary was speaking about with the unfitness to plead issue. I mean, indefinite detention, not in a prison, but in mental health treatment facilities, or oftentimes longer detention than would have been allowed if they had actually been convicted for the crime. So these are big problems. I mean, the other thing is that the insanity defense is relatively rarely used in comparison with the number of convictions that are done. So I think this does raise larger problems in the criminal justice system than also with why do we need the insanity defense? Shouldn't we have our criminal offenses constructed in such a way that the intent requirement within them, the mens rea, actually encompasses these issues, that intent needs to be there in order for the person to be convicted of the crime. And then the other thing I just wanted to raise is that in the United States in particular, I know studies have been done recently highlighting that there's a vastly disproportionate representation of minorities and people with disabilities in the prison system. So if the insanity defense and similar things were meant to not hold people with disabilities responsible or somehow keep them out of the criminal justice system, whether that's right or wrong, it's actually not serving that purpose anyways. So those are just a few problems I wanted to highlight that are probably larger but definitely exist in the United States.
Thank you very much.
Could I just make
Yes.
Say one more thing. The Australian Human Rights Commission has just done an extensive consultation on access to justice issues. And if it's okay, we'll put the link in the Dropbox for the report, because it's quite a very good practical report.
Oh, that'd be very helpful, I think.
Highlighting practice.
I've been interested in looking at that myself.
Helen?
That's great.
I was thinking also the 20 Years, 20 Stories link, so people could see Marlon's story.
Yes.
Because it's astonishing when you see it. It's difficult to understand how that could have said,
Yeah, and also, I mean, those 20 Years, 20 Stories would be a great resource on lots of the topics that we've covered. Dee's story would have been excellent yesterday in terms of... so we'll put those in the Dropbox for everybody.
Brilliant. Eleanor, you They're all coordinators from the technological
We're
department.
building a resource center in the drop. That's great.
Janet?
I'll just highlight a few things that have come to mind. I don't repeat what others have said. One is the work that Disability Rights International is doing in Guatemala, whereby they did some reporting and documenting of abuses against women with psychosocial disabilities who were being trafficked across the street to the prison. And this was, of course, with the involvement of the prison officers. So this link between human trafficking and disability, not a lot of attention has gone to it, but that's important. And they've taken a case for precautionary measures for the Inter-American Commission, I believe it is. I don't know the status of that, but that's something to look at. It's important. The other issue is sort of protective regimes gone horribly wrong. I had some friends working on a Monash University sponsored project, and they were from New Zealand, and there had been a statute enacted to effectively protect persons with intellectual disabilities who had been accused of fairly serious crimes and who were not being accommodated or supported appropriately within the regular prison system. So the statute was intended to address this, but it put them in a sort of separate detention facility, and then it over time it became apparent that they were being detained for far, far longer than they would have had they stayed in the regular system. So lots of advocacy around that. The Northern Ireland Prison Service has a human rights advisor, and they've actually adopted a disability action plan, which I thought was quite interesting. I had the opportunity to visit them at one point. And then finally, my colleague Michael Schwartz at Syracuse University Law School runs the Disability Law Clinic. And this past year, they decided they take on a theme every year. And this year, they were focusing on prisoners with disabilities and access issues. And they did a study, and they found there were several hundred, I want to say 800, I may have that wrong, several hundred deaf prisoners across the United States. And Michael Schwartz is one of the only deaf law professors in the United States, so he took a big interest in this area, and he was finding instances of deaf prisoners being isolated, put in solitary confinement, no access to sign language interpreters, no access to their lawyers with a sign language interpreter. So that's some work that he's litigating currently, and I think they'll be coming out with some more work and research on that area.
Good. I'm not going to say much because I think I just want to reinforce the points that Anna's made. So I'll just say two things, which is that, yes, I think the issues that disability highlights within the criminal justice system show that the criminal justice system is not working the way it was intended and does need to be reformed for everybody, and people with disabilities would benefit from that and should be part of that reform. And also that these general provisions like fitness to plead, maybe diversion out of the criminal justice system for certain kinds of offenders, and perhaps is also reasonable accommodation in the prison system. Particularly diversion and fitness to plead are things that we could think about retaining if they were made disability neutral. So if they were available to people on an equal basis, I think then that would meet the requirements of Article 12. But that requires a much bigger discussion that we don't have time to go into now. But we're happy to talk to people about that afterwards, I think.
Pass on the whole area of criminal law and disability and all that. It's a whole topic in itself, isn't it? Pass you on to Lucy. Right.
Sure. I'm just going to say a couple of words about alleged offenders with disabilities in the criminal justice system. The first is in England, our Law Commission has just done a piece of work on fitness to plead. They based their recommendations very heavily on a kind of old paradigm approach to legal capacity. So they want a functional test of capacity to address issues around fitness to plead. And they came across the literature around Article 12 of the Convention on the Rights of Persons with Disabilities quite late on, I think, in their work. And there's actually a statement in their most recent report saying that the requirements of Article 12 appear to them to be incompatible with the European Convention, and they have given clear precedence to the European Convention. So I think there's a clear need, and that stands in quite strong contrast to the approach taken by the Australian Law Reform Commission, who aren't bound by the European Convention. Do we need to wave our arms? Oh, we do. So that's kind of, it's quite interesting to compare the Australian Law Reform Commission's interesting proposals on fitness to plead with what happened in England. And if anyone's in England, perhaps they could respond to the Law Commission with suggestions. I wanted to make another comment about alleged offenders and regimes of detention. One of the things we see in England is the use of preventive detention to prevent people committing crimes on the basis that they lack mental capacity and it's in their best interest to be stopped from committing a crime. So these are regimes of indefinite detention to protect the public in the name of protecting the individual, and they don't even involve a proper trial of facts or anything like that, and they're not regimes of detention that could be imposed on anyone else. So that's very, very troubling use of legal capacity legislation there. I want to say something quickly about victims of crime. There has been, in fact, the criminal courts have done much better than the civil courts in England around looking at special measures to help people give evidence, and that's it's unhelpfully called vulnerable witnesses, but that includes people with disabilities. It also includes women who are alleging having been victims of sexual offences, and all manner of people who might find giving evidence problematic. So we're doing slightly better there, and the civil law system could learn a lot, I think, from the criminal law system. But we do come across problems around competence and credibility affecting people with disabilities, particularly mental health problems and intellectual disabilities, if they're victims of crime. And I just want to tell you a quick story to illustrate this. 10 years ago, the regulators for health and social care came across one of the most horrendous and widespread instances of abuse of people with learning disabilities in residential care and independent living services. The police investigated, and the police report says things like people were tied to their wheelchairs for 16 hours a day. They were restrained to give them medication, they were given cold showers to punish them. And the police report then says no crimes were identified. Now, if someone came into my home and tied me to a chair for 16 hours, gave me a cold shower and forced me to take medication, I think they'd be pretty quick to identify a crime. So there's something, again, about the context of care and about incapacity issues which clouds the perception of somebody as a victim of a crime. Nobody who was abused in this Budoc scandal in Cornwall, none of the alleged offenders were even prosecuted. They didn't even attempt a prosecution because of issues around the credibility of the witnesses. 10 years later or so, there was this abuse scandal at Winterbourne View, and all of that was caught on tape. The only successful prosecutions at Winterbourne View were for offences that were caught on film. So I think there's a real issue here around how successfully we can prosecute crimes if we're not prepared to believe people when they make allegations around those crimes that really, really desperately needs to be addressed. And a lot of that's around attitudes more than anything else.
Thank you, Lucy. Michael.
Just 2 quick comments. I think first of all, it's the complexity of legal capacity in the context of, criminal liability. Because on one hand, we are doing a lot of advocacy around the right to decide. On the other hand, generally it's like we're telling the public, people can commit certain crimes and get away with them. So of course, it also becomes a very, very difficult discussions in terms of legal capacity. The other discussion which I've had in Kenya is about the establishment of mental health courts, which I'm not too sure what they mean and what they operate. As an alternative, especially for persons with psychosocial disabilities. And based on the work that I've done with Miriam in the Kenya National Commission on Human Rights, the other interesting bit that I found when monitoring rights of persons with disabilities, especially for persons with physical disabilities, is the kind of situation sometimes they live in detention centers. Because we found that, for example, they're not allowed to have crutches. And the argument is, of course, that it can be used as a weapon. And that person have to keep on crawling from one room to another, which of course becomes something which is very, 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 very undignified. So I think those are some of the issues that probably I've really encountered when monitoring the rights of persons with disabilities in Kenya. Thank you.
Thank you. Now, thank you very much. I saw that you had your hand up. You wanted to make a contribution. And another gentleman there, and it's good to see people whose voice we haven't heard earlier. No, you have the floor. No. Yeah.
Sorry, because I got really very interested in all this, and I said, oh my God, I got a little bit lost. Well, first of all, I have to tell you that I'm not a lawyer, that I'm an anthropologist. Good. And that in that sense, I want to make like connections between all the cultural factors that I pay more attention than the laws. And also as someone who works with disability rights funding, what we have perceived is that it is not only the system who is denying access to justice to people with disabilities, it is also the NGOs who do not work with people with disabilities, who are obliterating or denying or simply not taking into consideration the situation of people with disabilities. And just very briefly, for example, we have a case in Lebanon of a person with Down syndrome who has been in jail for I don't know how many years. And when an organization who works with people with intellectual disabilities approach an NGO working with access to justice, that said, what is Down syndrome? So we are talking of that level that we also might need to address eventually. No? Thank you.
Thank you. That's a very important observation, the development of silos within civic society groups and failure to share the information. Now, the gentleman behind you. Thank you.
Sorry, just a question for Lucy based on what you just said on special measures in the UK. I know, just picking up on one of the big special measures which is just coming into force now is under section 28 of the Youth and Criminal Evidence Act 1999. They're now admitting pre-recorded statements in court from vulnerable victims. And I'm just wondering, has that met any opposition just on the basis of the rights of defendants who would say in an adversarial system, it's how can we cross-examine someone on the basis of pre-recorded evidence and that the jury don't get to directly apprehend the witness when testifying? It's just something that anytime I give a presentation, I'm always asked that question. People seem to criticise the measure, but I don't know how to respond. I was just wondering if you'd have a response.
Lucy?
I'm afraid I haven't been following this development closely enough to give you a confident answer, yes or no. I'm sort of looking at Anna Lawson to see if she might possibly have some knowledge on this coming from the UK. Anna, do you have know anything about this? We're just getting a mic to her.
Thank you very much. I've just had the joy of reading the UK reports for the Access to Justice project that Jenny was giving us examples from this morning from the Irish perspective. And certainly that UK report hasn't identified any particular controversy around that. It's always hard proving a negative. That doesn't mean there isn't, but it hasn't picked up on that, and it has picked up on other controversies, like the lack of a statutory right to a registered intermediary for defendants with disabilities.
Okay. All right, thank you very much. And now coming to the close of this session, so Jenny, I think you want to... Yes, please.
Just to respond to your question there, Ireland has a kind of remarkable High Court case under Section 16 of the 1993 Sexual Offences Act, which in and of itself is a discriminatory protectionist law that is a law protecting people with disabilities from assault. And in that, under Irish evidentiary laws, if you are a vulnerable person, you can provide evidence through video testimony. And so in this case, a case brought under this act was trying to admit video recorded testimony from the victim, and the defendant said that they didn't know the person was vulnerable. That was their defense. And that if the DVD was allowed in, because the DVD is only allowed in because the person is vulnerable, it created a presumption of vulnerability and undermined the defendant's defense, and the High Court ruled that the person was not entitled to video recorded evidence in that case, and the person had to testify. Yeah.
And just on a related matter, that's Section 23 of the Criminal Evidence Act, is that what we're talking?
Yeah, well, this is
in the UK. But here in Ireland, there is in cases where you have children with an intellectual disability who can't give evidence, there's reliance on Section 23 of the Children Act 1997 to introduce evidence in civil cases, and then you have the Criminal Evidence Act as well. Now, okay, I think we have to draw it to a close. I'm afraid you'll have to meet some of the speakers in the course of their coffee and inveigle them in to talk to you. Is that all right? The gentleman, you had your hand over the back. So, ladies and gentlemen, no, don't start moving yet. You have heard the various roundtable discussion about accessing justice around the world. So we're having the coffee break now, and thereafter, ladies and gentlemen, thereafter you will be applying your learnings to this state of Gilead, is it? Yes. In relation to the representation and preparing for the moot court in the case of Serena Joy versus the Republic of Gilead. Gilead, right. So we can put on our thinking caps. Obviously, the groups assigned to the various tutors are all set up on the notice board outside, and we're meeting here and in another room. Is that right?
Yeah, so just to remind people, this room, if you're on the team that's being mentored by Anna and Piers, that's the team that's representing Serena Joy, you'll be in this room. If you're on the team that's representing the Republic of Gilead, which is being mentored by Teresa and Lucy/Janet, will be in 129, which is the large room behind this room where we had the meeting at lunchtime and some of the workshops yesterday. Okay, so go directly to whatever room you're in for your team rather than coming back here, unless you're in this room. Okay, thanks.
All right, thank you very much. Thank you.